Welcome to the annual Law Library of Congress Constitution Day Lecture. I'm Aslihan Bulut, and I have the privilege and honor to serve as the Law Librarian of Congress. Each year, we celebrate Constitution Day with a lecture, panel discussion, or an interview with a distinguished legal scholar. Constitution Day, which is officially known as Constitution Day and Citizenship Day, is a federal commemoration observed each year to mark the signing of the U.S. Constitution on September 17, 1787, and to recognize all who, by coming of age or by naturalization, have become citizens. This year, we are honored to have two distinguished legal scholars with us, Dean Risa Goluboff and Professor Mark Tushnet. Dean Risa Goluboff is the 12th and the first female dean of the University of Virginia School of Law. She's a legal historian whose scholarship and teaching focus on American constitutional and civil rights law, and especially their historical development in the 20th century. She's the author of two books, The Lost Promise of Civil Rights and Vagrant Nation, Police Power, Constitutional Change, and the Making of the 1960s. Dean Goluboff clerked for Judge Guido Calabresi of the U.S. Court of Appeals for the Second Circuit and Justice Stephen Breyer of the U.S. Supreme Court. Professor Mark Tushnet is the William Nelson Cromwell Professor of Law Emeritus at Harvard Law School. Professor Tushnet is the co-author of four casebooks, including a casebook on constitutional law. He has written more than a dozen books, including a 2-volume work on the life of Justice Thurgood Marshall, A Court Divided, The Rehnquist Court and the Future of Constitutional Law, Weak Courts, Strong Rights, Judicial Review and Social Welfare Rights in Comparative Constitutional Law, Why the Constitution Matters, Advanced Introduction to Comparative Constitutional Law and Advanced Introduction to Freedom of Expression, and has edited 8 others. Professor Tushnet clerked for Judge George Edwards and Justice Thurgood Marshall. Dean Goluboff will interview Professor Tushnet about his book on the Hughes-era United States Supreme Court, which is titled The Hughes Court from Progressivism to Pluralism, 1930 to 1941. This book was funded by the Holmes Devise, a gift funded by the late Justice Oliver Wendell Holmes, which established a U.S. Permanent Committee for the Oliver Wendell Holmes Devise, which includes the Librarian of Congress to support the work of documenting and disseminating the history of the United States Supreme Court. Professor Tushnet will take questions from the audience for 10 minutes at the end of the interview. We will have staff members with microphones who will walk over to persons who have raised their hands during that time so we can all hear your questions. And with that, I am pleased to turn the floor over to Dean Goluboff and Professor Tushnet.
Thank you. Thank you so much for those introductions, and thank you for having me here, and it's wonderful to see all of you. It is particularly wonderful for me to be doing this today. Partly, I was a fellow in the Kluge Center many years ago, so I feel like I'm returning to the Library of Congress, and that makes me happy. And second, Mark Tushnet has been a really influential scholar in my own development, and so to have the opportunity to talk to him about his work is a real honor, and to celebrate this book. And then the third thing I would say is, this is the perfect book for Constitution Day. So not only is it part of the Oliver Wendell Holmes Devise, which makes it a perfect book for this place and this day, but it's also, you can see it's a large book. It is a very heavy and large book, and it is about a crucially important period in the Supreme Court's history and in the meaning and interpretation of the Constitution, although, as we'll talk about, maybe not quite as transformative as some people think, according to Mark, but it's a legacy of the court that we're still addressing today. It is also a book that is based in good part on papers that are here at the Library of Congress. So Mark and I were reminiscing about sitting in the manuscript room, and my second book, which I was writing when I was a fellow here, I used a lot of manuscripts for as well, so it's perfect for that too. And then finally, throughout the book, Mark references multiple points in a Constitution Day speech that Franklin Delano Roosevelt gave in 1937, and so it feels particularly fitting that we should take this occasion to celebrate this incredible achievement and this really masterful book that Mark has written. So I thought we would start by saying, by asking you, this is an enormous undertaking. It took 15 years, I think, to write. Not that you were doing that the whole time, only that, but can you just give us the big picture? What does it mean in your title to go from progressivism to pluralism?
There are, excuse me, sort of two themes in the book that I would stress in a sort of shorthand version. The first is about what happened in 1936-37, which is the time that most people associate with the Hughes Court. And I actually opened the book with the phrase adapted from a historian of science. And I write, there was no constitutional resolution in 1937, and this is a book about it. So something clearly happened in the period 1936-37. The law after it was somewhat different than it was before, but pinning down exactly why the change occurred and exactly what it was is extremely difficult. And the first third of the book is really an effort to try to explain why there wasn't a constitutional revolution, but you can still write something about it. Then there's the theme stated in the book's subtitle, From Progressivism to Pluralism. The general view about the Hughes Court is that it consisted of a group of conservative reactionaries and progressive, of the time, liberals who were at each other's throats for most of the period. I found out when just reading the materials that that's an inaccurate description, that virtually everyone on the court from its beginning in 1930 to the late 1930s, when some changes did occur, was committed to something like a progressive vision of constitutional and administrative law. The conservatives on the court were somewhat less committed to a full-throated version of progressivism than the liberals were, but as I think I put it somewhere in the book, by 1938, the liberals could look back, and they were actually pretty disgruntled at that point. But if you look at what had happened, they had a very expansive agenda of which they achieved maybe 80% of it. They were disgruntled that they didn't get 100%. The conservatives looking at it would say, well, we're not happy with the sort of last 5%. We're okay with the 75% of movement that has occurred. So the first part of this, this theme is it's overstated to describe the court as divided between progressives and anti-progressives or reactionaries. And I think in the bibliographical essay I say I tried to avoid using the term reactionaries anywhere in the book in my voice. I may have quoted some people who said that. But towards the end of the period, you do see the emergence of a somewhat different vision of the way the U.S. system of government works. The progressives had a vision that the government in all its phases was aimed at accomplishing the public good, which had some sort of objective, not entirely political essence to it. And then at the end of the period, you see pluralism emerging, where the government is devoted to advancing the interests that are the product of the contention among interest groups. And that is new. It's not fully consolidated by the time Hughes retires, but you can see it emerging. So that's the from progressivism to pluralism theme.
So you also say that there are a couple of other dichotomies that we like to use to talk about the court that you think are not quite right. Formalist, realist, that often was thought to match onto progressive, conservative, and then this is slightly different. This isn't about particular justices, but in thinking about what did happen in 1936, 1937, the debate between internalists and externalists. So can you say a little bit more about exploding various dichotomies?
Yeah, so first on the formalism versus realism or purposivism or something like that. Early in the book, I quote from Chief Justice Hughes' speech at I think it was the dedication of the Supreme Court building, in which he himself says that some people are in favor of, now I'm forgetting the phrase he uses, but formalist rules, and others pay attention to the realities of social life. And he obviously was advocating for paying attention to social reality. When you look at, so there was this sense that there were sort of different ways of doing constitutional and administrative law, and they sort of are captured by formalism and realism or something like that. But when you look at both individual justices and any particular doctrinal area, you see that the judges and within the areas, the cases move fluidly between formalism and acknowledgement of social reality. At one point, Hughes, I think, says, maybe it's Cardozo, that well, we do use these rules, but they're sort of precipitates of experience in dealing with cases over and over again. They fit into certain patterns, and it's handy to use them. But if they don't work well, we abandon them. And that's pretty much what all of them thought. That one, they would disagree about whether it was appropriate to use some formula to solve a problem, or rather pay attention to social reality. There's some, I find, interesting estate tax cases in which that comes up, where the conservatives are formalists about it, and Stone in particular, Justice Harlan Fiske Stone in particular, says, yeah, let's look at what this provision actually does in reality, and it turns out that the things that the formalists worried about never actually occurred in the real world. So they do disagree about it, particulars, but it's sort of overall jurisprudential themes. I've come to think, I don't talk about this in the book, but I've come to think that they saw themselves as lawyers using a whole bunch of tools flexibly as they thought appropriate under the circumstances, not committed to any particular jurisprudential scheme. So that's the
formalist, realist.
That's the reason I criticize the use of that distinction as an analytic device. Again, it helps thinking about particulars, but it doesn't help in looking at the court overall. On the internalist, externalist.
Can you say for everyone what does that refer
sure.
to? Yeah.
So this distinction arises in connection with the attempt to explain what happened in 1936, 1937. And the internalist argument, which was developed mostly at the University of Virginia Law School, says that if you look at the cases as they were actually decided, you can see them as sort of organically working out the logic of some prior decisions. Even though it looks like there's a dramatic shift in 1936-37, in fact, if you look at the cases in detail and how they were argued, you see that nobody changed dramatically there were changes in the way the cases were presented and the facts of the cases that allowed different results to occur because of individual idiosyncrasies. I'll talk about that in just a moment. But mostly it was working out the logic of earlier decisions. The externalists say, well, you know, what happened in 36-37 was that in 1936, the conservative reactionaries struck down a whole bunch of New Deal statutes. Franklin Roosevelt ran against the court in 1936, won an enormous victory, proposed a court packing plan early in 1937, and concerned about the structure, the state of the court, Chief Justice Hughes and Justice Roberts changed their minds, responding to this sort of pressure from outside. That's why it's externalist. The externalist story, everybody's known for a long time that in detail, the externalist story couldn't be right. So one of the most obvious things is that there's a crucial decision in which, in 1936, the court struck down a minimum wage law. In 1937, it upheld an essentially identical minimum wage law. The vote on upholding the law was taken in December. It's a little tricky to get this be completely accurate, but it was taken in December 1936. Roosevelt announced the court packing plan in January 37. So the court packing plan in itself couldn't have influenced this dramatic change in outcome. I can go into detail, enormous detail about this, and if anybody's interested. Even that story is not entirely accurate, but at the same time, it is pretty clear that you can't account for everything by saying it was just the organic development of doctrine in cases presented somewhat differently. I'll give two examples. One is that in these minimum wage cases, Justice Roberts said he voted as he did in 1936 because the state hadn't argued to reverse an earlier decision. And he changed his vote in 1937, not because in 1937 the state did argue for overruling. That's not precisely accurate. The state had sort of argued for overruling in 1936 and actually didn't argue for overruling in 1937. So you know, he constructed a story that made sense for him of what does appear to be a change in mind. And then about, maybe 10 years after he left the court, he gave an interview to a biographer of I think it was Harlan Fiske Stone, and the biographer asked him, you know, what happened in 36, 37? And Robert says, I can't really remember it in detail, but Hughes was a really persuasive guy. And he talked with me, and I don't know why, but he was smarter than it. Roberts has this very charming line, which he may not have ever uttered, but his line is, who am I to curse the good Lord for not having made me as smart as Cardozo, Hughes, Marshall, and so on. He had a sense of where he stood in the sort of legal talent, and he understood that Hughes was much smarter than he was. And he just says, somehow, I don't know exactly how, but Hughes persuaded me to do what I did. And Hughes probably was at least aware of he certainly was aware of what was going on externally. So the full story is a combination of internal developments and external pressures.
Mm-hmm. So the Holmes Devise volumes are all organized around, a court and a chief justice. So let's talk a little bit about the justices on the court. Can you say more about Justice Hughes? Tell us, who was he?
Yeah, so Chief Justice Hughes, the first thing that people say about him was he looked like a Chief Justice, or Santa Claus, a combination of Santa Claus, this big white beard, and Jehovah. That was one of the lines. He had been a very prominent progressive politician, governor of New York. He'd been appointed to the Supreme Court. He'd run for the presidency against Woodrow Wilson in 1916 and came very close to winning. He resigned from the court, actually, only after being nominated. That is, he didn't resign in order to be nominated. He resigned after he was nominated. And then he went on to be Secretary of State and a member of the Permanent International Court of Justice. And he was nominated in 1930. Everybody agrees he was phenomenally smart. He taught himself 3 or 4 languages by the age of 6. He was, for all practical purposes, homeschooled. The one blot on his record is that he worked at it. This didn't come out until after he had passed away. He had written essays for students, other students for pay. So he was a plagiarist, or they were plagiarists.
He was a cheater.
He was a cheater. He was a cheater. But he was, and he ran the court, very strictly. He was by the end of his tenure, there's some grumbling about how strict he was. Frank Murphy got annoyed with him. Stone got annoyed with him at not allowing discussions to occur. And this is, I found this interesting when I went to his papers. He has this enormous career, so he's got papers from when he was governor and from Secretary of State. And the papers from his period on the Supreme Court are extremely thin. And what he did save were what are called the returns, the sheets of paper in which other justices say, I agree with your opinion. But the ones he saved, I think this is right, all of the ones he saved were things like, this is a great opinion, spectacularly well done, and so on. He had, in this sort of, he had an ego that I think may not have come out as much in public as actually occurred. Okay, I'll go on to my favorite justice.
Yes, I was going to ask about others. I have some others, but you go on to your favorite.
I'll just go on to my favorite.
Can I interject one thing? So to say, when you look at the justices' papers, they've culled them, right? They've decided, which I don't know, sometimes seems crazy. You think about document retention. It was up to the justices what to save, right? So that's why it's so interesting that this is what he saved, right?
And Justice Roberts, the first Justice Roberts, I guess we have to say, destroyed all his papers. And he was one of the crucial actors, so it's really annoying that there's nothing there.
All right, tell us about your favorite.
So my favorite is the obscure Willis Van de Vanter, who wrote very few opinions, but he was William Howard Taft's, as Chief Justice, sort of provost marshal or something. He was the one who did the work that Taft wanted done. He had very good relations with members of Congress. He'd been a prominent Republican politician in Wyoming before he joined the court. His papers, so he wrote very few opinions. His papers are quite extensive, none of which, actually I think, with one exception, none of them deal with the court. He writes a letter every day to his mother in Indiana and every day to one of his sisters who are one's in Indiana, one's in Wyoming. And he comes across as just this very nice guy who had a wife who was medically fragile from the time they married until the time she passed away. She went through enormous medical procedures. She had cancer, which you couldn't mention at the time, and then he mentioned it, and then she had a very severe stroke, and he writes about all her efforts to recover. Is just very devoted to his family. And so he had a brother who was a sort of wastrel, and he had to keep cautioning his mother not to give in to the demand, to the requests from his brother for money, because it was just going to be spent down, go down the drain. What I like most about it, he does come across as a nice guy. And what I liked most about reading through his papers actually was, more than anybody else in the papers, you get a sense that he, as all of them almost certainly did, actually had real lives. They weren't just members of the court. It wasn't the only thing they did. And it comes through in the papers. It's not, So I should say he made two relevant comments about the sort of the court's work. One is right after Roosevelt took office, he closed the banks to avoid bank runs. And Van Deventer wrote a letter, this one I think is to his sister, saying, what Roosevelt did was, I think, the right thing, although it made it hard for me to send my monthly $25 check to Mother. And then in one of the early cases, a case called Blaisdell, he does describe to his sister what happened in the case. And he says, well, I'm really proud. We had this argument. They had the argument. We went to conference. I laid out the argument for why this statute was unconstitutional. It took me about an hour to go through it in detail. And then Justice Sutherland wrote an opinion that tracked my argument point by point. And he was clearly very proud of this. He didn't like the outcome. It came out, Sutherland was a dissent. But he was clearly very proud of the work he'd done on the case.
They're human, right? They're human. Yeah, they're human. So, so some are legendary as well as human. So Justice Holmes was on the court for the first couple of years, right? One of the most famous Supreme Court justices ever, the Holmes Devise, right? So what role did he play at the beginning of the Hughes Court?
So he was there only for a few years. He was in his late 80s into his 90s, and he retired when he was told he was getting too old. There's a radio broadcast on his 90th birthday that's available. You can hear most of it maybe it's even on the Library of Congress website, but it is available to hear. And you hear this very old man's voice. He was legendary, of course. He was probably the most serious legal thinker who's ever been on the U.S. Supreme Court, and founder of what came to be known as legal realism. What I found most interesting in this period, remember he's very old at this point, is that his biographers and people who write about him, who follow him from early on, describe him as he comes across as austere and having a vision of the world that is sort of bleak and unattractive. And that may have been true about his vision of the world, but all of his colleagues who interacted with him talk about how charming he was, that he just, he would fall asleep in the middle of conversations, but when he was—
That can be charming.
that he was a storyteller, that he was captivating in person. We could tell stories because they went back 90 years, but this is, my version of this is I think this is true. He met John Quincy Adams as a child. So He doesn't contribute an enormous amount to the Hughes Court's work because he's not there for very long, but seeing how they responded to him changed my sense of who he was as a person.
So this is all very nice. These are lovely relationships and human people. So tell us about Felix Frankfurter and Harlan Fiske Stone and how maybe they had some not great tendencies that they reinforced amongst each other.
Yeah, so Stone had been a law professor, not a terribly distinguished law professor, but he was dean of the Columbia Law School for a while, sort of as a compromise candidate to calm things over. And Frankfurter knew him from before Stone was appointed to the court, and they had an extensive correspondence both before Frankfurter was on the court and while Frankfurter was on the court. And each one of them had, as I suppose we all do, had a tendency to get annoyed at colleagues on occasion. And the colleagues they got annoyed at were both Stone, a moderate progressive, and Frankfurter, a fairly devoted progressive. So they were mostly annoyed at their more conservative colleagues. And when one of the conservatives did something that it's easiest to describe for a period when Frankfurter was not on the court. So Frankfurter would read an opinion from one of the conservatives, and he would write a letter to Stone about how outrageous this was and how the person couldn't analyze a legal issue in any decent kind of way. And Stone would reply in basically the same terms. So they reinforced each other's worst tendencies. And I think Stone eventually was named to be Chief Justice after Hughes retired and was not a terribly successful Chief Justice, partly because I think he was reacting against how he thought Hughes had run the court, but also because he was just a pricklier personality than Hughes was. And Frankfurter, of course, was on the court then, and so the two of them could sort of, reinforce each other.
Kibitz. And kibitz, the Yiddish word, right? They would, yes. So in this book, one of the things that I love about the book, which I also love about your prior work and was influential in my own work, is that, as you say, in Bentham's words, it's judge and company, right? It's not only the court, it's not only the justices who are instrumental in developing constitutional doctrine or Supreme Court doctrine, but the lawyers are crucially important. That has been a key part of my own work, following on some of your work. So can you say more? Was that always a part of the way you saw this project, or was that something that developed as you were, reading the cases? And, the briefs really play a very important role in the book. And, how did you come to decide that the lawyers played such an important role, and especially in, the 36-37 period?
Yeah, I started the project with the assumption that I was going to have to pay attention to the way the lawyers presented the cases to the court. And I carried that through fairly systematically. I had a sort of template for writing up a description of what happened in the cases, and the template included a recitation of the facts as presented in the record and sometimes as supplemented by other material, and then a description of the briefs where they were at least illuminating of the final argument, the final opinion, and then a description of the opinions with an effort to see whether or to what extent the lawyers' presentations mattered to the court. And I think the ultimate answer is that probably overall you want to say the way the lawyers argued did sort of shape the atmosphere of what the court was doing, but that you can't very often trace specifics in opinions to arguments being made by the court. There are a couple, I'll give you a couple examples. One, a contrary, where you actually can you can see the influence. And there are a couple of cases in which they're criminal cases in which the United States it turns out to be the respondent, and the Solicitor General submits a brief saying, here's why the lower court decision should be affirmed. And then in two cases, it's the same Solicitor General, Thatcher, puts a little note afterwards. Well, one case, he puts a little note afterwards in which he says, the brief you just read is the best case I could make for supporting the judgment below, but I'm not really persuaded by it. And the court reverses the conviction. And then in another case, this is a case that's still taught, called McBoyle versus United States, taught in statutory interpretation courses. Thatcher presents a fairly weak brief with an appendix quoting all that involves whether an airplane is a moving vehicle under a statute prohibiting interstate transportation of stolen moving vehicles. And he presents an appendix in which all the statutes referring to airplanes and moving vehicles occur, and it's just overwhelmingly apparent from looking at that list that when Congress enacted this statute about moving vehicles, it had no intention to cover airplanes. And that's what Holmes says in the opinion. Holmes writes very cryptic opinions, so the trace of the brief doesn't show up, but it's clear that that's influential. But let me give you another example. In the 36-37 period, one of the issues is the scope of Congress's power to regulate the economy, and in particular, the price fixing and labor provisions of various statutes. And these were always constitutionally, pretty much everybody knew they were constitutionally vulnerable under existing law. But in one of them, Department of Justice lawyer named Robert Stern comes up with this incredibly brilliant argument about why this regulation is constitutionally permissible. It involves characterizing the nature of the economic activity that is being regulated in a very particular way, not a way that other people had seen. It's really good. The court ignores it, as far as I can tell. And then when the issue comes back to the court, Hughes has a formulation that is sort of recognizably similar to Stern's, but not quite the same. So there is something there, but again, you can't trace direct kinds of influence. The other thing that I would mention about lawyers is that there's a visible change in the way opinions are written and briefs are written from the beginning of the period to the end. At the beginning of the period, opinions are sort of flat assertions of legal propositions with a citation or two attached to them, and a little bit of reasoning that follows. Briefs consist of quotations from prior cases and then string citations. By the end of the period, these are very hard for modern lawyers to read and understand. So why do you think this is a persuasive kind of argument? It's just very puzzling. By the end of the period, the opinions and the briefs are recognizably modern. And that change occurs, I think, mostly because of the influence of the Solicitor General's office and partly from the diffusion of Department of Justice trained lawyers into the general bar. You still see these old-fashioned things coming from practitioners from small towns in Indiana who happen to have a case in the Supreme Court. But by the end of the period, they're easy for a modern lawyer to read.
Interesting. So one last question about the lawyers. You know, there have been theories, Peter Irons, about, you know, how important the lawyers were to the shift from the court striking down to then upholding the New Deal legislation. And that's not a theory you think has a lot going for it.
No, so the argument is that in the cases that were struck down involved statutes that were sloppily drafted, and that the government hadn't been able to develop a strategic litigation campaign that would present the cases in the statutes in the best light to the Supreme Court. After the court struck them down, a new set of lawyers came in and they redrafted the statutes to make them less constitutionally vulnerable, and then the court upheld them. I think that's mostly, well, there are two parts to this. One, I think part of that story occurs because the later lawyers tell it to historians. They want to present themselves in the best light. And so they sort of do try to disparage their predecessors. Maybe more important, the first statutes actually, I think, were not all that badly written. They were produced under enormous time pressures. You know, they're known as the 100 days of the first 100 days of the Roosevelt administration. All this stuff was done then. There was very little what we would now call capacity in the government to generate really, you know, comprehensive statutes and defenses. The lawyers, I think, did a reasonably good job under the circumstances they were presented. The National Industrial Recovery Act is sort of a central feature in this story about bad lawyering. Part of the story is, well, they had these codes of good behavior that became enforceable law, and they applied to, you know, the spun cotton candy industry and, you know, a whole bunch of, you know, I can't remember the details, but like the straw broom industry and so on. It's true, they were there. They were adopted. What happened was that the government, under the Hoover administration, had been encouraging the development of these codes, and they were there sort of on the shelf, ready to be adopted, and they just took them off the shelf.
Don't you also point out that the smaller, more obscure industries, they were able to organize faster, so the examples that came up were not from the biggest industries, right?
Right. And then it took a lot of time to negotiate the codes for the larger industries. Steel, in particular, was so the first cases were all these, you know, trivial cases. The case gets to the Supreme Court involves the retail sale of chickens. It turns out the government's position in that case was, at the very least, much more defensible than most people then thought it was, and than many people now think it was. But on this litigation strategy point, the government actually had a decent litigation strategy, but the litigation wasn't entirely under their control. But they did have a case which the court had granted review in the wood manufacturing industry, a very large industry in the South. And then they had to dismiss the case because of a collateral development. And so the case that got to the court was this chicken industry case. So, they did the best they could. The first set of lawyers did the best they could under the circumstances they were presented with. And just on the second set of lawyers, some of the redrafting was done according to what the Supreme Court said. So one of the cases that was struck down, Justice Brandeis wrote an opinion saying this statute is unconstitutional because it has these 5 flaws. And so the Justice Department lawyers went back and they rewrote the statute that eliminated 3 of the flaws, left 2 of them. The case comes back to the new statute comes back to the Supreme Court. The court says they've eliminated the 3 flaws. It's true they haven't really eliminated the other 2, but who cares? And they uphold the statute. They really don't explain why the 2 flaws no longer matter.
3/5 is good enough.
Right.
That's great. So I'm going to pull back in a minute, but one more question about the court and its operations and how you write about it before I go a little bit bigger. So one is, we've talked a lot, and we'll talk a little bit more about 36, 37, but what's amazing about this book is, even as you say, a big chunk of it is about that and kind of the blockbuster cases. It's really also about all the cases, right? It's about the relationships between the cases in any given moment or across different kinds of doctrine, and trying to see, how they saw the cases at the time. Can you share a little bit? Where does that cash out? Where is it that you find attention, to the everyday work of the court as illuminating for how we understand it?
So that is a very complicated question. I think that the place where I address it most directly is in a chapter where I write about all the other cases that occurred in 36, 37. That there are these blockbusters that, there are books written about them, but in the same period, they were deciding a whole bunch of sort of ordinary rate regulation cases. There was a tax case in which they held a federal tax statute unconstitutional. Nobody makes a big deal about it. It was seen as routine. And at some level, the lesson is that they were doing a job. And the job consisted of a whole range of things, not all of which we would regard as terribly important, but each one of which mattered to the judges who were deciding them. So to come back to Willis Vandevanter, the reason he wrote so few opinions was that he would get assigned an opinion in some. He was a Western water law expert, some Western water law case. And he would, these days, these cases, they used to be when I was clerking, they're referred to as the dogs. We have to decide them, but nobody cares about them. And, you get assigned one of these cases and you just, churn out an opinion. Well, Vandevanter would get one of these cases and he would dig into it. And the more he dug into it, the more he found it was really complicated. And he kept digging. And eventually Hughes would say to him, look, you got to stop. And sometimes he would stop. Sometimes Hughes would say, well, I'll assign this to somebody else. But these were part of their regular docket. Another example I talk about a bit in the book is before 1937, when Erie Railroad versus Tompkins is decided, the court decides every term 10, 15 cases involving state law. Just what's the law of Illinois on this matter? Those all go away after Erie and Tompkins. But they took them seriously. They were trying to figure out what Illinois law was, what the right rule was.
So I have some questions about kind of how this fits into larger themes and about the book that way. So stepping back a little bit. So one question, and maybe the answers to this are so obvious it doesn't even make sense to ask the question, but why is the switch in time that's 8 of 9, which may not have been that at all, and maybe a transformation, a revolution that wasn't, that you wrote a book about. Why is it still so important? Why do historians and legal scholars spend so much time on it?
I think the answer is that it is the most dramatic episode in which there is a plausible, maybe even persuasive case to be made that important Supreme Court decisions are the direct result of the external political environment. As I've said, I don't think that's completely accurate, but there is enough truth to it that it provides an exemplar of the persistent claim that the court's actions are always, in some significant sense, political. This sort of just crystallizes the idea that the court's decisions are political in the relevant sense. And not, I think anybody who's been reading the newspapers over the past year sees that discussion recurring now. And it's been a, persistent theme, goes up and down in waves. But the 36-37 episode is as clear an example. It's not crystal clear, but it's as clear an example of this constitutional law is politics idea as we can get.
So I was going to save these for the end, but it's such a good segue. I'm going to ask them now. So I have a couple of questions about what you see as the relationship between then and now. So one is, part of what you've said and what you write in the book is the way I think people at the time described it and the way people since have described it was these, two entrenched camps, the progressives and the reactionaries, and that there was a lot of distance between them, and that they were quite clearly delineated. And you say no, right? There wasn't as much distance between them. They were largely in the same project, and it did make me think about today. And people describe the court quite similarly. Do you think there will be a historian in so many years who will say, actually, we've all gotten it wrong, and the justices are closer together or share more than is readily apparent in the moment?
Well, time will tell, right? So we don't know what's going to happen. So early in the book, I say, I've tried to tell this story from the perspective of the judges at the time. They were facing these cases on a day-by-day, year-by-year basis. And then I quote an opinion by Justice Souter, who says, when they made these decisions, they didn't know what was going to happen. But we know what happened. And from a historian's perspective, of course, it's very difficult to, be uninfluenced.
Right, hold it in abeyance, right?
By knowledge about what happened. But I did my best to do that. Well, we actually now don't know what's going to happen. And there are lots of scenarios that might play out. There is this sort of structural similarity in that there's not even a possibility of a structural similarity, which is that when Roosevelt got to the presidency, and in particular after 2 or 3 years, he had control of the executive branch and control of Congress, but faced a court that had been appointed by conservatives, by Republicans, some of whom had appointed moderate progressives like Stone and Roberts and Hughes, but others of whom had appointed quite hard-line conservatives, Van Devanter and George Sutherland, for example. And so Roosevelt was facing a court that had a composition different from political coloration, different from the political coloration of his governing coalition. What we have now is the structure is the first part. That is, you have a court that's been appointed by a Republican Party that has a particular coloration. But what we don't know, and we have a president at the moment who has sort of a Congress on his side. So that's sort of like Roosevelt, but it's much weaker than Roosevelt's position was, and we don't know what's going to happen. You know, if well, you can play out the scenarios. It's from my perspective, it's not not an uninteresting fact that discussions about what now people are calling court reform are much more vigorous now than they have been for the past generation, really. Now, you know, they will fizzle out if some things happen, and they may, you know, become even stronger. Those discussions may become even more vigorous if other things happen.
So that was my other presentist question, and then I'll go back. But it leads perfectly into: are there lessons for that conversation about court reform that you take from the court packing incidents in 37?
I think there are two that I would stress. One is that the court packing proposal came much closer to success than most people today think it did. It was, you know, Laura Cowman has a book coming out laying this out in enormous detail, but the sort of bottom line is that if the plan was on the verge of being adopted in the Senate because Majority Leader Joseph Robinson of Arkansas had an enormous amount of personal ties. And he called in all of his political capital to support the court packing plan, in part because he had been promised the first seat that was added to the court. So
That'll motivate a person.
Right. And so it was on the verge of coming to a Senate vote. It was very hot in Washington that summer. And like a week before the scheduled vote, Robinson died of a heart attack, mostly induced by the heat. And then all the personal chits that he'd called in just went away. So that's one part of the story. Another part of the story, this is the crisis was resolved when Willis Van Devanter retired. And he retired in 1937. He'd been wanting to retire mostly because of his wife's medical condition since around 1930, 1931. I'm not entirely sure of the dating of this, partly because I read his pre-1930 letters with less care than I read his post-1930 letters. But certainly in 1931, he was thinking about retiring. He's got a letter saying, before the 32 election, I think I'm going to retire no matter who wins the election, whether it's Roosevelt or Hoover, although of course he wanted Hoover to win. And then as part of the Hoover's and then Roosevelt's austerity program to respond to the Depression, Congress cuts the pensions of retired Supreme Court justices. This turns out to be significant. The pension scheme for judges who resigned allowed them, was thought to require that they couldn't cut the pensions for judges who retired. If you resigned, then your pension could be cut. The statute for justices said you have to retire, you have to resign, you can't retire. So you had a pension and it could be cut. And Congress cut the pension of retired justices. Van Deventer said he was always worried, for reasons I can't understand, he was always worried about money. And he said, if they cut my pension, I won't be able to live. So I'm just going to have to stay on the court. Representative Hatton Summers of Texas was chair of the Judiciary Committee for years. He'd been trying to eliminate this ridiculous distinction between retirement and the different treatment of lower court judges and Supreme Court justices. He wanted to set it up so that justices, like lower court judges, could retire and then continue to have their pensions. Roosevelt presents his court packing plan. Hatton Summers says, oh, great, people are thinking about court reform, let's pursue this one. People in the White House say, it's not really something we care about, it's not going to interfere with our proposal. So Summers gets this statute enacted, and Van Deventer says, now I can have my pension, and he announces his retirement. So there's, there are two parts of that story. One, it's just at some level chance. Again, a retirement that occurred in some sense coincidentally. But also the other part is that retirements can matter. Van Deventer was replaced by Hugo Black, and that was the end of the story for the old court.
That's really fascinating. So I take it back that I have one more presentist question, and then we'll see if we have time for a couple more non-presentist questions. But the story you're telling, right, it ends with the end of the Hughes Court in 41, and as you point out, civil liberties isn't fully developed at the time, but we can see directions that it's going to take. But the creation of the administrative state through the post-1937 doctrines, this is the New Deal settlement that people talk about today, and then gets added onto with what happens later and in the Warren Court. I know you've taught legislation, you've taught regulation toward the end of your career, and so you have lots of thoughts about the administrative state. And I'm curious, what do you see as the relationship between what you write about in this formative period in the volume and what you see happening today with regard to the administrative state?
Okay, so let me say one preliminary point, since you mentioned civil rights and civil liberties. One of the most striking things is that from the beginning, the Hughes Court was a civil rights, civil libertarian court. Our standards now are different, but you don't find, if you look at the Hughes Court's record on issues of civil rights and civil liberties, it's predominantly victories for claimants of civil rights and civil, not always, but predominantly victories for them.
But you see continuity there, right? Yeah, that's not changed in that part.
Right,
yeah.
Right. On the administrative state, part of part of this problem in thinking about the current situation is that the modern administrative state was hadn't been fully consolidated by 1941. And the one place I actually do go beyond 41 in some detail is to describe the enactment of the Administrative Procedure Act in 1945. And now that I think of it, so that story is one in which political challenges to the most extensive interventions of the administrative state through mostly the National Labor Relations Board, but secondarily the Securities and Exchange Commission. Those political challenges were substantial, and they were accommodated in the Administrative Procedure Act. Just on those two agencies, the National Labor Relations Board was seen accurately as a body favoring organized labor, and in particular favoring the Congress of Industrial Organizations, the more left wing of the National Associations of Labor Unions. That was the perception, and it was clearly accurate. The Securities and Exchange Commission is a curious example. It was regularly attacked politically, although most of the large Wall Street players actually favored the SEC. They thought it was stabilizing their industry. I think today you see something similar in attacks on the environmental regulatory state in particular, but also the area that I used to teach some on, the occupational safety and health statute. These are also expansive interventions into the economy. One of the innovations in the administrative state in the 1960s was to shift from sectoral regulation of airlines for the Federal Aviation Administration or railroads for the Interstate Commerce Commission to regulations of this economy as a whole with the EPA and OSHA. So those are under attack. The resolution in the 40s was a legislative resolution that is the court sort of upheld the expansion of the administrative state. The parallel would be to think about, could we respond, could Congress respond to the challenges being mounted, the political challenges being mounted to EPA and OSHA through sort of modernized Administrative Procedure Act? I know there are some discussions in the administrative law community along those lines. Or alternatively, could the reconstruction be done by the courts? And I mean, what we're seeing now, I think, is the beginnings of an effort along the second line, the courts trying to do the reconstruction very gingerly, I think, because they understand that they probably don't have the tools to do a decent job. But again, this is something we'll see play out over time.
All right, my last question before we go to audience questions is, the Holmes Devise volumes are all organized around a court with a chief justice, and I'm curious how you found, you just talked about the APA as one of the few things that you kind of pushed beyond 1941. What are the benefits and drawbacks or the challenges of working within that framework of a court under a Chief Justice?
So there are challenges because it's not Taft died, and so Hughes came to the court. There's no natural reason for that. It's not like there was a crucial election that led to Hughes's appointment to the court. And he retired in 1941 because he was old and ready to turn the reins over to somebody else. So there's no connection between the arrival and departure of a Chief Justice and anything of intrinsic historical circumstance. If I were attempting to periodize the court in a way that included the Hughes court period, now with what I know, I probably would want to start in sort of the mid-1920s with the appointment of Stone, and then Roberts and Hughes in 1930, because then you probably then would get the consolidation of the progressive vision, and I'd probably want to end it sometime in the 1940s, where the transformation to pluralism was clear. I don't know, maybe with the 1945 or 1950 desegregation cases, something like that. So that periodization would capture something of significance in the rhythm of the court's history. On the other hand, and I did feel that I was pushing the thesis to pluralism a little hard in the book. I don't think I was wrong in seeing that it was there, but it was very much sort of in utero. It was there, but not as much of it as I would like to have been able to talk about. On the other hand, the period does include 36, 37, and there's a way of telling the story that connects, 30, 31 to 40, 41, that makes sense of the episode in 36 and 37. So it was something of a challenge, but not a tremendous obstacle to coming up with a sort of narrative arc for this period.
Well, I certainly don't think it was an obstacle because you did, and it was masterful. So with that, open it up to questions. There are folks coming around with microphones.
Hi. I was interested, Mark, in what you said about how the Hughes Court really was, almost from the beginning, a civil liberties and civil rights court to some extent. I wonder, how does the famous footnote 4 in Caroline Products fit into this? I've always wondered to what extent it was a conscious or self-conscious effort by the court to signal its beliefs or what it saw in the future, or whether it was just slipped in there by an adventurous law clerk.
Yeah, so footnote 4 in the Caroline Products case says, tries to provide a sort of comprehensive theory about when the court should be aggressive in constitutional review. It was drafted by a law clerk named Louis Lusky, who went on to teach at Columbia Law School, and revised in some significant ways by Stone, who was the author of the opinion. And it has several paragraphs. The key paragraph, which is the one that Lusky and Stone worked on, says we should be aggressive when we're dealing with, I'll shorten it, statutes that adversely affect discrete and insular minorities, which is where you get the pluralist kind of idea coming in. They circulate this opinion. Hughes says, seems okay to me, but you sort of left out the place where we're aggressive when the Constitution itself identifies specific constitutional rights. And Stone says, yeah, that's right. And they insert a first paragraph that goes through these specifically enumerated rights. And then the general theory is in the second paragraph. The genesis of, so I'll say a couple of things about the footnote itself. I do use it to signal the emergence of the pluralist vision. It's 1938, I think. In Lusky's original draft, he says, there's a phrase tied to the discrete and insular minorities that says, where it adversely affects discrete and insular minorities, legislation might not adequately reflect the public interest or the common good or something like that. Hughes changes that to say where it affects those discrete and insular minorities, the political processes that we trust, that we rely on to prevent the adoption of oppressive legislation might not operate well. So there's a shift from the language of progressivism, which is public interest, common good, to the language of pluralism. Exactly how conscious this is Stone's contribution. Exactly how conscious he was of what he was doing, who knows? The origin of the footnote is also a little unclear. There's an earlier opinion in the same term involving regulation of truck lengths, in which, again, it's an opinion by Stone, which this theory is alluded to, but not developed in the detail as it is in the footnote. So Stone somehow had that, Stone or Lusky, it's the same term, so Lusky's there. Stone or Lusky somehow had this idea rattling around in his or their minds. Lusky has a memoir describing the origin of it. He describes the details of the drafting, but he doesn't say where the idea came from. And I don't know, I have this sort of, I don't say this in the book, but my guess would be that that somebody teaching, Stone retained his ties to Columbia Law School. He took law clerks from Columbia. Lusky was a Columbia graduate. My best guess is that somebody at Columbia was muttering things along these lines. Thomas Reed Powell is the most likely one, although I don't know whether he still was at Columbia at this period or not. He eventually moved to Harvard. But my guess is the idea was sort of in the air in Columbia, and Lusky and Stone talked about it, and they sort of came up with it.
Great. Other questions?
Thank you. Let me just apologize because this is not so much a question. I just want to say, Professor Tushnet, thank you. As a lawyer, your essay, Abandoning the Defensive Crouch, has been sort of the template for my legal career. And so it's just a pleasure to be here and hear you talk, and just wanted to communicate that to you, what a profound effect it had on me. So thank you.
Well, thank you. It led to a variety of interesting reactions. Including we had to change our home telephone message because I got a bunch of hate calls on our phone. But anyway, but thank you.
Any other questions?
We're going to have a brief introduction to the Constitution annotated. Turn this on. There we go. And thank you. First of all, I'd like to thank the Law Library for sponsoring this program today, and also Mark and Risa for a tremendous presentation. This has been a great way to celebrate the Constitution. So I'd like to take a few minutes to introduce you to the Constitution Annotated, the online Constitution Annotated, which is at constitution.congress.gov. This is the Constitution's 3rd anniversary. We launched it in 2019. The Constitution Annotated is the 5th iteration of a project that Congress began back in 1795 when it passed legislation to provide for a copy of the Constitution to be printed and distributed to every member. By the 1820s, these copies of the Constitution were being enhanced with indexes at the end, and then by the 1870s, they had started to add lists of citations to those. By the turn of the century, as well you can imagine, these lists were really, really lengthy. So lengthy as to make them not as useful as they had been previously. So Congress, in its wisdom, passed a law in 1912 to provide for the preparation of a Constitution annotated with explanations of Supreme Court decisions. And this is our Constitution annotated. You can see a picture of it. The library's Congressional Research Service has been preparing the Constitution annotated, first in its predecessor agency, the Legislative Reference Service, since 1938. And so accordingly, the Constitution annotated complies with CRS's standards of objectivity, authoritativeness, timeliness, and nonpartisanship. In 2014, the Constitution annotated celebrated its 100th birthday. At that point, it had grown to some 3,000 pages, making it somewhat difficult to maneuver and navigate around. So, following the centennial celebration, the library, in their wisdom, decided to reimagine the Constitution annotated for the 21st century. And so here we have an online Constitution annotated, which was launched on Constitution Day 2019. Since its launch, it has continued to serve members of Congress and their staff, as well as educating millions and millions of people around the world on the Constitution and across the nation. So first, a couple of things that, for people who may not be familiar, I'm just going to give you a little highlights of some of my favorite aspects of it. The Constitution annotated has 2 main search features. The first one is a search bar. You can see that at the top of the screen. That appears on every page. So wherever you are in the document, you can always look for material. You also have filters, so you can try to streamline and narrow your searches as you do. We come here, the search bar, the searches results will lead you to an essay on the topic, several essays if you want. These essays are arranged so that they represent sort of the organization of the book. So if you really wanted to, you could just page through by clicking on the arrows on either side. One of the things I really like about the online Constitution annotated is that it has links to the cases that it's referring to. So you don't have to go look for the cases, you just click on them and you can read the justice's words right before your very eyes. The other way that we have of helping people find information in the Constitution annotated is our browse function. And as you can see, the browse function follows the Constitution's organization, and it can be expanded so that people can find more information in more detail. And this is particularly helpful for people who may not be familiar with constitutional law terms. They can just sort of browse through it and see what seems to be closely approximating what their interest is. Finally, one of the favorite things I have about the Constitution Annotated is that it provides additional information. It provides information from other library collections concerning the Constitution, and it also contains reports that are written by congressional research attorneys and feature constitutional emerging issues. Finally, if you have any questions about how to use the website or any questions about constitutional research at all, the Law Library of Congress is the top place to go. So there is their contact information. And thank you very much. I hope everyone has a wonderful Constitution Day.
So I'm happy to close, okay. So let me just say what a privilege it has been to talk to you, Mark Tushnet, about this incredible book. And I hope many of you will read it or read parts of it. But it is learned and nuanced and comprehensive and smart and interesting and a real feat. So congratulations and thank you for this conversation.
Thank you.